Member for Pascoe Vale.
Thank you, Acting Speaker. And I too rise to support the Private Security in County Court Amendment Bill for 2024. And in doing so, I'd like to commend the Minister for Police, his office and department for bringing this bill to the House. And I'd particularly like to acknowledge the Minister's Chief of Staff, his long-time Chief of Staff, Kieran Barnes-Jenkins, for his years of service and effort to the Victorian Government, and who's recently announced he'll be moving on to be a full-time dad. Acting Speaker, all Victorians deserve to have the right to feel safe in their communities, and as a government and indeed as a parliament, we should be working every day towards helping make Victoria a safer place, including across my community of Pascoe Vale, Coburg and Brunswick West. And whilst we're all aware and appreciative of the tremendous role Victoria Police play in maintaining our community's safety, it's additionally also about a number of other factors, including the way in which our community members are kept safe in places where Victoria Police members just can't physically be expected to be patrolling and monitoring around the clock, including at late night entertainment or licensed venues, and the role of early intervention and diversionary programs in our criminal justice and court systems, and how they can be leveraged to support crime prevention, offender rehabilitation and community safety outcomes for all. And essentially, Acting Speaker, this bill is about these two things. One, it's about enhanced standards and conditions across the private security industry, which has a large presence in maintaining safety across thousands of locations, including pubs, clubs, venues and events across our state on a weekly and daily basis. And two, the bill is about extending the operations of the County Court Drug and Alcohol Treatment, the DACT, which has been operating to promote recovery through rehabilitation of its participants and to protect communities from further substance-driven offending. Acting Speaker, turning first to the amendments in this bill relating to the security industry, almost 20 years ago to the day, the Private Security Bill of 2004 was introduced to the Victorian Parliament by then Minister for Police, Andre Hairmeyer. The bill replaced the Private Agents Act of 1966 and was the first formal recognition in this jurisdiction of the importance of a robustly regulated private security industry. One of the main drivers of the establishment of the Private Security Act of 2004 was the tragic death of cricketer, coach and broadcaster David Hookes during an altercation with the crowd controller outside a nightclub in St Kilda, I believe. The tragedy brought to the fore the importance of seeking to ensure that those entering the private security industry are properly trained and vetted by police to engage in these important high-risk roles. While the crowd controller in that matter was ultimately cleared of any wrongdoing, the events of that night highlighted the serious risks and potential consequences inherent in private security work and the need for better training and regulation. And together with a decision from the Council of Australian Governments to require people applying for private security licences to undergo probity checks, the Private Security Act in 2004 was a robust and progressive piece of legislation. And over the last 20 years, we have seen a much better regulated industry emerge, together with vast improvements in matters such as infiltration of organised crime into the security industry, which has been a huge step forward. However, a great deal has changed over those 20 years, and the private security industry is no exception. Over time, the industry has grown and diversified. This, along with social and technological developments, has required increasingly complex skills. Over that time, issues have also emerged with the way some members of the industry are prioritising profit over fair pay, work conditions, leaving a highly casual, mobile and vulnerable workforce in its wake. Key industry advocates have identified serious concerns about the rights of workers, the barriers to healthy business competition, and the behaviour of some trainers and workers that bring down the reputation of the entire industry. That is not to say that there are not many highly skilled security guards operating in our jurisdiction who make a significant contribution to keeping our community safe. This bill is not aimed at those types of individuals that I've just been referring to. It's actually aimed at the employers who do not pay fair wage and do not afford workers genuine flexibility and access to legal entitlements such as superannuation leave and insurance. It's aimed at those training organisations that do not deliver the required training and who sign off on untrained and wholly unprepared workers. And it's aimed at the workers who do not understand the importance of their role and do not have the skills needed to de-escalate and address emerging threats. Acting Speaker, the reforms contained in this bill are informed by the recommendations of the Victorian Government's review of the private security industry, which was released in December 21 and conducted by the Department of Justice and Community Safety. And by way of context, the review identified that the number of licence and registration holders in Victoria across the industry is significant. As of December 2020, there were a total of 32,700 private individual licences and 815 private security business licences across the state. There were also a further 3,745 applications for private security, and the Licensing and Regulation Division of Victoria Police, the LRD, cancelled 72 licences and suspended 67. The review received 52 submissions from a wide range of stakeholders, including namely workers and businesses, followed by peak bodies, unions and others involved in the industry. And the review identified that one of the key purposes of the Act is to, quote, regulate the private security industry for the purposes of ensuring public safety and peace. This purpose carries weight and responsibility and envisages high standards of professionalism across the sector. I refer the Chamber to page 8 of the review, which found that there are many private security employers and employees who are well trained, experienced and contribute to the positive public safety outcomes by conducting themselves with professionalism, integrity and skill. However, there are also those who do not fully understand their role, the importance of their role or the risks that the role entails. It is this sector for whom the recommendations are aimed at. Some of the key examples highlighted during the review that these recommendations go to include, for example, in 2011, a man who died after having a heart attack while he was being held and restrained by security guards in a prone position on the floor at Crown Casino and suffered from positional asphyxia. Some industry workers have suffered from detrimental impacts to their health and well-being as a result of workplace incidents such as physical and verbal abuse. Workers have reportedly been afraid to speak up in many instances about unsafe working environments, for example, where alcohol is served without regard for responsible service of alcohol laws, and crowd controllers who are left to deal with the consequences of that aggressive behaviour of patrons. Many observations were accounted for that a control centre operator at Victorian University, for example, used security cameras for improper purposes, such as seeking out views of female students in university residences. Crowd controllers observed to take no action to try to verbally de-escalate potential violent situations and stepping in only when physical violence erupts, despite clearly being aware of the building risk. And numerous examples were conveyed in the report of unsafe working environments and very bad outcomes around EBA bargaining agreements not being adequately supported and enforced. And of course, the report also subsequently was superseded by the COVID-19 Hotel Inquiry final report, which did note the impact of the casualised nature of the industry and opportunities for ongoing reform, which are reflected to a large degree in the reforms contained in this bill. Ultimately, the report put forward 21 recommendations, and this bill addresses 11 of those recommendations, which require the legislative amendment. And in this respect, Speaker, the bill makes, all of those following amendments, 3 of which include replacing the current 2-tier system, which requires most sectors of the industry to obtain a licence and others to obtain registration with a single-tier licensing system. Number 2, it introduces enforceable requirements for transparency and accountability when subcontracting security services. And number 3, requires workers in high-risk roles, such as crowd controllers, to undertake refresher training prior to licence renewals. And of course, Speaker, the state government is one of the largest procurer of security services in the state, and so this bill will help provide for better standards across the industry and subsequently the services through which security services have a presence on Victorian precincts and facilities. And some of those include at our major events precincts. The sector is so important. It contributes around $3.3 billion to the state's economy, employs over 15,500 full-time jobs. But in many ways, it is the standard of our security services at those precincts that play such an important role to maintain the vibrancy at those events. And again, having that vibrancy protected and secured is critical for economic and employment outcomes. The Grand Prix, for example, last year delivered a $268 million economic charge to our economy and supported over 1,100 jobs, $268 million. The Australian Open in 2023 generated $387 million, member for Frankston, and supported over 1,700 jobs. Speaker, I'd now like to turn briefly with the time I have towards the amendments on the County Court Drug and Alcohol Treatment Court, the DACT. My apologies. In relation to drug court amendments, drug courts are specialised courts that provide therapeutic approach to addressing the complex needs of offenders with drug and alcohol dependency. And traditional sentencing options can fail to adequately address the needs of drug offenders, and by contrast, the drug court model seeks to address underlying causes of offending by providing intensive drug treatment services to offenders. Addressing these underlying causes will ultimately enhance the wellbeing and community connectedness of participants by improving their relationships, housing stability and life skills, and reducing reoffending. And the County Court Drug Diversion Program was established here for a 3-year pilot in 2021, and this bill seeks to extend the operation of the Drug Court Division for a further 2 years. And I'd just like to highlight some of the outcomes thus far that are contained in the annual report of the County Court, and include having been funded to deliver and support 70 participants. The DACT in 22-23 received 57 referrals and imposed 42 drug and alcohol treatment orders. In June 23, there were 65 total active clients, and the DACT is actually building a waiting list, such as the growing demand on capacity. Of the referrals, 93% are for males and 7% are for women. 87% of referrals are for non-Aboriginal and Torres Strait Islanders, and 4% are for First Nations people. And many partnerships have been developed, including with St Vincent Hospital, with Centrelink, with Narcotics Anonymous, and employment vocational pathways.